That structural limitation is a profound reminder that even the highest aspirations of international law are often tethered to the political realities and self-interest of the most powerful states.
That's a perfect way to put it.
They created a law that could prosecute Nazi evil, but they made sure that the law wouldn't bounce back and implicate them.
Precisely. They established the standard, but they very carefully carved out the exceptions they needed to maintain the tribunal's unity and continuity.
So once this unprecedented legal architecture was in place, the stage was set for the prosecution. And the power of their case rested entirely on the clarity and thoroughness of Robert H. Jackson's opening statement and that mountain of evidence he prepared to present.
Jackson knew that this single statement had to define the trial for history. On Wednesday, November 21st, 1945, the second day of the trial, he began. And it wasn't a summary, it was a manifesto. The speech was nearly 25,000 words long.
25,000 words. That's an entire book.
It's an intellectual and logistical feat. It took him 3.5 hours to read aloud.
That is less a statement and more a complete analytical deconstruction of the Nazi regime. What was the core message he was trying to communicate to the world?
The tone was incredibly analytical, deliberate, and extraordinarily thorough. He was consciously matching the momentous nature of the trial. He started by directly addressing the power imbalance, stating that they were charging guilt on planned and intended conduct that involved moral as well as legal wrong, abnormal and inhuman conduct. But his central intent was laying the legal foundation for the future. He framed the trial as essential for civilization, arguing that this juridical action would put the forces of international law, its precepts, its prohibitions, and most of all its sanctions on the side of peace.
So it wasn't just about punishment. It was about the legal codification of peace itself.
Absolutely. And the strategy he chose to prove this systematic, abnormal, and inhuman conduct, that's what made the trial unimpeachable. He decided to rely almost entirely on the defendant's own records.
That was the genius of the American approach, wasn't it? To eschew possibly volatile or emotional eyewitness testimony for the cold, hard proof of Nazi bureaucracy.
To convict them with their own words.
Exactly.
It was strategically brilliant. Allied armies had captured millions of German documents, reports, memos, meeting minutes, financial ledgers. Tens of thousands of these were translated and submitted as evidence. The prosecution realized that relying on the official German record documents signed, dated, and filed by the perpetrators themselves would create a legal record that denialists could never fully erase.
The dry, bureaucratic language of destruction was ultimately more devastating than any single tearful testimony could have been.
Far more devastating.
So let's get specific. What were some of the most critical documents they presented to establish those charges of conspiracy and crimes against peace? How did they prove the aggressive war was planned, not just something that happened?
Well, they meticulously documented the planning structure. To prove the conspiracy to wage aggressive war, the prosecution submitted military planning documents that were finalized long before any actual conflict broke out.
So actual war plans.
Actual war plans. They included Case White for the invasion of Poland, Plan Green for the takeover of Czechoslovakia, and the chilling Barbarossa contingency, the plan for the invasion of Russia. And this plan bore the initials of defendants sitting right there in the dock, like Keitel and Jodl. These weren't spontaneous acts of defense. They were long-term, calculated military operations.
And what about the economic conspiracy, the part that linked the financiers like Hjalmar Schacht to the military preparations? That detail takes this from a morality play to a meticulously investigated case against a full-blown criminal enterprise.
That was absolutely vital for establishing the breadth of the conspiracy. They relied on documents proving how men like Schacht, the former Reichsbank president, secretly financed rearmament. He developed the notorious MEFO bills.
MEFO bills.
It was a complex scheme that essentially allowed the Reich to obtain massive credit from the Reichsbank without technically violating existing laws that limited direct government lending.
So it was a massive bookkeeping fraud designed specifically to fund a military buildup necessary for aggressive war.
Precisely. Schacht himself even conceded that the device enabled the Reichsbank to lend by a subterfuge to the government what it normally or legally could not do. The prosecution showed how the economic architects had built the financial foundation for the aggressive war, demonstrating that the crimes extended far beyond just the military chain of command.
Okay, now we have to move to the heart of the crimes against humanity charge, the documentation of the Holocaust. What were the key documents presented to the tribunal that solidify the evidence of the final solution conspiracy?
3 documents in particular were used to prove the bureaucratic, state-sponsored nature of the genocide. First and foremost, the Wannsee Conference Protocol from January 20th, 1942.
This protocol. It was compiled and heavily edited by Adolf Eichmann, and it's often seen as the smoking gun, isn't it? The bureaucratic blueprint for industrial mass murder.
It is the ultimate proof of intellectual collaboration. It outlined the expansion of Nazi mass murder to encompass 11 million Jews across Europe. The document proves the coordination and agreement among senior regime officials, from the SS to the Ministries of Justice and Foreign Affairs, to collaborate on a continental scale in the final solution to the Jewish question.
It was chilling proof of a state machine dedicating all its resources to genocide.
All of its resources. And to prove the atrocities on the ground, connecting that planning to the brutal reality, they used the perpetrators' own detailed reports.
That's just.
Secondly, they submitted the original Stroop report. This was SS Brigadier General Stroop's official after-action report detailing the systematic destruction of the Warsaw Ghetto in the spring of 1943. And it wasn't just text. It included photographs taken by the SS themselves, meticulously documenting their efforts to exterminate the Jewish residents.
I recall the ghastly detail in the sources regarding the captions on those photos.
The captions are devastating. One infamous photo, which was used as evidence, was titled by Stroop to show the driving out of Jewish bandits. But the photo itself clearly showed women and small children being forced out of hiding at gunpoint.
So it was unimpeachable proof that the terms the Nazis used, partisan, bandit, were just bureaucratic camouflage for the systematic murder of civilians.
Mostly women and children. And the third documented item, the report on the gas vans, it demonstrates this grotesque industrialization and even the psychological cost of the killing process on the perpetrators.
What did that report say?
Document 501 PS was a captured report detailing the functional challenges of the gas vans. It talked about technical issues, noted that the vehicles were well known to the civilian population as death vans, and, critically, described the atrocious spiritual and physical effect the unloading of the victims had on the operating crew.
These weren't notes from a victim. They were dry, technical notes from the perpetrators worried about efficiency and their staff's morale.
Exactly. That bureaucratic detachment made the horror completely undeniable.
And beyond the reams of paper, the prosecution also used film evidence, which must have delivered a visceral shock to the courtroom that no amount of reading could ever match.
Oh, the visual evidence was crucial for the public record. They screened several films. One was called The Nazi Plan, shown on December 11th, 1945. It was compiled solely from German official newsreels and propaganda.
So using their own footage against them.
Right. It demonstrated that the defendants were intimately involved in Hitler's inner circle and planning activities, proving the political conspiracy from their own sources.
But the real shock must have come from the footage gathered by the Allies upon liberation.
Absolutely. The film Nazi Concentration Camps, which was screened on November 29, 1945, was arguably the most dramatic moment of the entire trial. This was footage filmed by Allied photographers at the liberation of places like Nordhausen and Buchenwald.
And the sources note that the film was so profoundly shocking.
It affected everyone, the judges, the spectators, and even the defendants themselves. The skeletal remains, the mass graves, the physical evidence of torture. It was so disturbing that the trial had to be adjourned immediately afterward to allow everyone to compose themselves. Later, the Soviets added footage of the liberation of Majdanek and Auschwitz, compounding the visual evidence of genocide.
Even though documents were the priority, they still used eyewitness testimony, right?
Yeah.
Especially from the commanders themselves.
Yes. Well, the documentary proof was the foundation. Testimony from survivors and, critically, from perpetrators laid the groundwork for details about Auschwitz and the Einsatzgruppen.
The mobile killing squads.
Right. The prosecution called Einsatzgruppen commander Otto Ohlendorf to the stand, and he testified, matter-of-factly, about the mass murder of 80,000 people by the troops under his command.
Having the man who directed the killings confess on the stand must have been devastating to the defense.
It was essential for demonstrating individual guilt. Another witness, SS General Erich von dem Buxelewski, also admitted that German anti-partisan warfare was essentially just a cover for the mass murder of Jews. Their words, combined with the German documents, created an insurmountable, overwhelming case that transcended mere accusation.
So let's shift our attention now to the men in the dock. We had 22 of the most important surviving leaders. Political, military, economic, all standing trial. And most were, perhaps unsurprisingly, unrepentant.
That's right. These men represented the highest echelons of Nazi power. The planners, the military chiefs, the financiers, they had every opportunity to confess, to apologize, to show remorse, yet most maintained this rigid posture of denial, claiming ignorance or adherence to the Führerprinzip.
The highest-ranking individual in the dock was Hermann Goering. He was the most visible and, by all accounts, the most defiant of the defendants.
Goering was a central figure, Reichsmarschall, commander of the Luftwaffe, plenipotentiary of the four-year plan. He was centrally involved in the overall conspiracy, including issuing the explicit order in 1941 for preparations for a general solution of the Jewish question. He was convicted on all four counts, making him one of the clearest examples of the IMT's success in targeting senior leadership.
But his final act was one of defiance. He denied the tribunal the satisfaction of carrying out its sentence.
It was the ultimate act of self-determination in political theater, even in the face of absolute defeat. On October 15, 1946, just 2 hours before he was scheduled to be hanged, Goering committed suicide by ingesting a cyanide capsule he'd somehow concealed from his guards.
The ultimate escape. That must have been a crushing moment for the tribunal, knowing their most prized defendant, the one who symbolized the entire regime outside of Hitler, had literally slipped through their grasp.
It was a massive embarrassment for the military police responsible for security and a symbolic, though ultimately fruitless, act of rebellion by Goering. It cast a brief shadow on the procedural aspects of the trial, but of course it did nothing to undo the conviction itself, which stood firm based on the evidence.
Now, let's discuss the surprising acquittal of Hjalmar Schacht, the economic architect. Given his critical role in financing the Nazi war machine with that clever MIFO bill scheme, why did the Western Allies decide he wasn't guilty of conspiracy or crimes against peace?
This is one of the most contentious points of the trial, and it really highlights the differing legal standards at play. Schacht's role in the economic foundation of rearmament was undeniable. The prosecution showed that he knew Hitler planned aggressive war and willingly served the regime.
Okay.
But the Western Allies' majority opinion found that his economic